Good morning, everyone. My name is Carmen Perez. I am Vice Dean for International Relations of the Law and Social Sciences School here at Universidad Carlos III de Madrid. And on behalf of the Dean, Rosa Rodriguez, it is an honor for me to welcome you all to our university. It is indeed a privilege to have the opportunity to host this seminar organized by ICEL and coordinated by Professor Abad Castelos. So I thank her and the other coordinators for their work. I will give now the floor to the speakers, first of this opening table. First, I will give the floor to Christina Boyd. She is chair of the IUCN World Commission on Environmental Law, co-chair of the Paris Agreement Implementation and Compliance Committee, professor of Public International Law, and coordinator at Pluris Courts, Center of Excellence at the University of Oslo in Norway. She will be with us online because she's in Egypt right now, and she has a meeting immediately, so she has to speak now. Then I will give the floor to Pablo Ruiz Jarabo. He is a Deputy Director General at the Directorate General for the United Nations, International Organizations and Human Rights of the Ministry of Foreign Affairs, European Union and Cooperation of Spain. Then Manuel Blasco Gomez, Brigadier General, Deputy Director General at the Directorate General for Planification and Environment of the Ministry of Defense of Spain. And finally, to Montserrat Abad Castelos, Professor of Public International Law at Universidad Carlos III de Madrid and co-director of the ICEL's International Secretariat. So, Christina, I don't know if you can hear us. Yes? So, whenever you want, you have the floor. Thank you very much.
Thank you very much, Dean. Good morning to all of you. It's a real privilege to be invited to this very, very important seminar. I would like to express my appreciation to Professor Montserrat Abad Castelos and the Universidad Carlos III de Madrid, as well as ICEL, for organizing this webinar and seminar. And on behalf of the IUCN World Commission on Environmental Law, I would like to express our deep appreciation to be part of it. Now, I would also like to commend you on the choice of topic, protection of the environment during armed conflict. We all know that this is a very unfortunately timely and relevant topic. Armed conflicts pollute and destroy the environment, and they're often leaving a permanent scar on the landscape and on biodiversity of affected states. The Russian war inflicted on Ukraine demonstrates very clearly the devastation caused to fauna and flora when states engage in warfare on a massive scale in areas rich in biodiversity and natural resources. But this year, we could also see the most significant legal advance in the legal framework intended to prevent and remedy environmental damage from war since the 1970s. Because for more than a decade, the United Nations International Law Commission, the ILC, has been undertaking a detailed exercise to identify, clarify, and reimagine the rules that states and non-state actors alike should follow during armed conflict in order to protect the environment. Earlier this year, in May 2022, the outcome, 27 principles on the protection of the environment in relation to armed conflicts, or the PAIR principles, as we call them, were adopted. These principles articulate valuable norms for militaries to avoid the worst environmental impacts of war. Importantly, they suggest that multilateral agreements to protect the environment continue to apply during armed conflict. And those norms contained in those multilateral environmental agreements, which are negotiated so difficultly, and that's why I'm calling here from Egypt, because I'm attending the United Nations Climate Change Summit here in Sharm el-Sheikh, and I see how difficult it is to get to an agreement on the international level in relation to protection of the environment. But those multilateral agreed rules continue to apply alongside use in battle during armed conflicts. And the reflection, analysis, and further development of these rules through practitioners, through academics, is a very, very important exercise, which will be likely taken up during this seminar today. And again, Manse, I commend you to the choice of this topic, and I wish you very, very successful discussions during the day. Thank you so much.
Thank you. Pablo, whenever you want.
Thank you, Carmen. Thank you to the organization for letting us the possibility to introduce this seminar. The other day, reading an article in Kirsty's group webpage, they said how one of the main effects of climate change and environmental crisis is the fight against shepherds, between shepherds and farmers, because they fight for the same scarce resource, which is the land. So there is something curious about this. The first news we have of an armed conflict in history is in the Genesis. It's Cain and Abel, and they were a farmer and a shepherd fighting. According to the Bible, they fight because of envy, but shepherds and farmers, when there is scarce resources, they fight each other, and they did thousands of years ago, and we're still doing more than ever now. So this is something historical, but which is taking regrettably a strength of deterioration, which calls for actions. And in this point, the principles of the International Law Commission are very, very relevant. It is environment in armed conflicts, but let me raise the attention of the principle 10, which calls of corporate due diligence, corporations, enterprises. Now, environment, we have realized that it is what the Secretary General always calls a new public good. He's trying to impose the idea of public goods in the international community. He being a Portuguese, I wonder if is the idea of dominio público, public domain, that we have in continental law, and also in Portugal, I suppose. So it's much more than armed conflict. One of the main risks and attacks to the environment, if they are not conscious, are transport of goods, transport of petrol, etc. We are seeing right now in the papers, the Prestige, 20 years. So it is armed conflict, but it is much more than that. It's a very difficult problem. You can see it from every point of view: regulation, policing, promoting, anything. It's a challenge, very difficult to deal with. You know, this is humanitarian law. There is something that is happening right now with humanitarian law, with the Ukrainian war, as the person said. We have, in the Security Council especially, we have beautiful resolutions, very well written about any problem: women, peace and security, attack to children, sexual violence. They are very well built, very well drafted, and they are normally approved by unanimity. Now, what happened in the Security Council in December 21, very, very short time ago? Some countries, which were not non-permanent members of the Security Council, tabled a resolution, like former ones, very well written, very completed, very well difficult to say no to that resolution. And what happened? This is very interesting. Russia vetoed the resolution. That was months before the war, and India voted against it, and China abstained. So in a habit of approving very good resolutions, in this problem, in this particular topic, there was not unanimity. This is something to reflect about. Because maybe this was a foretelling what is happening in the humanitarian field. We have, as I said, we have beautiful resolutions, beautiful conventions, but a huge problem of applicability. You hear more and more voices saying beautiful things, but we do not apply them. Last year, we passed a threshold, a very, very worrying threshold of displaced persons all over the world, more than 100 million for the first time since the Second World War. So something is going wrong. Anyway, we have to legislate, we have to do conventions. And when something is going wrong, there are two ways of thinking. One of them is the revisionist one. We must change everything. We must build new instruments, new tools. And the line of thought that thinks that we must come back to basics. Now, also in the Security Council, there was a debate 3 months ago about protection of civilians. And the Chinese representative said, we, the Security Council, have to build new bridges, new ways of working. And the Secretary General answered to him, we have to apply the Charter, the Charter of the United Nations, Chapter 6 and 7. Everything is there. It needs improving, but let's escape from revisionist approaches. We want to change everything for the sake of an improvement that it remains to be granted. Let me refer lately to the directives, the guidelines of the International Red Cross about the environment. They were published at the end of the 21, and they say a very interesting thing. They say that if you apply the basic principles of use in bello, which are distinction, proportionality, and prohibition of indiscriminate attacks, you can resolve the problem of attacks to environment and to civil population and so many things. So the principles of the International Law Commission are very stuck to these basic principles, I think, and that's a good thing. But anyway, it's a very, very huge task, but doing, you can find solutions rather than crossing your arms. Thank you.
Hello. Hello, good morning. I want to thank the International Council of Environmental Law and Carlos III University to offer me the opportunity to participate in this workshop. Although it's said that the first victim of war is the truth, it cannot be denied that people is its natural victim and the great object of the suffering that any armed conflict entails. Also, it's obvious the potential of military action to cause damage to the environment, the silent victim of conflicts. In the words of Doe Ware, Research and Policy Director of the Conflict and Environment Observatory. Considering both, the importance of environmental risk is normally hidden behind the immediacy and drama of human suffering and images of destruction. The Intergovernmental Panel on Climate Change points out in its 2022 report that wars, in general terms, do not usually change the climate. However, these days we have the opportunity to witness how a conflict such as the invasion of Ukraine affects the approach to plans to combat climate change and causes significant risk to the environment. Recognizing the impact not only in a limited area of operation, but also in scenarios that could eventually reach a global scale, the vital need to maintain a safe, healthy, and sustainable environment imposes an ethical obligation to plan and conduct military operations, considering their impact on nature in order to prevent and control as far as possible the damage inherent to their conduction. The protection of the environment in the development of armed conflict is also a legal requirement, being included in texts such as the Additional Protocol 1 to the Geneva Convention of 1949, which imposes to war action the protection of the natural environment against widespread, long-lasting and serious harms, and prohibits retaliation attacks against the natural environment. But it's also worth to take a look at an interesting book published in China in February 1999, Unrestricted Warfare. It proposes tactics for developing countries to compensate for their military inferiority during a high-tech war. The text acknowledges that the new principles of war are no longer using armed force to compel the enemy to submit to one's will, but rather are using all means, including armed force or non-armed force, military and non-military, and lethal and non-lethal means, to compel the enemy to accept one's interest. From the last sentence, we can gain a sound understanding of the warfare of the future, where it is included ecological war among the forms of envisaged war fighting. Therefore, it can be seen that the risk to the environment do not derive only from the unforeseen or neglected consequences of war operation, but also that there is the possibility of reaching a state in which environmental damage constitutes one more objective of the operation in order to undermine the enemy's defense capacity, its freedom of action, and ultimately its will to resist at the evidence of such a magnitude of damage that compromises not only its present defense, but the future viability of its territory and society. In short, we cannot forget the natural result of the fact that human beings will many times use every conceivable means to achieve their goals. For that reason, we must be aware that the existence of a legal framework that imposes severe obligation on the planning and conduct of military operations does not ensure that they are universally accepted, or that, if so, they are not breached by some of the participants in a conflict, if considered that it can be decisive to achieve victory or at least to avoid a complete defeat. Yet, even if faced with this, it is of the utmost importance to have a legal body that establishes a set of obligations and responsibilities for the development of military operations in a respectful manner with the preservation of the environment, compatible with the nature of that operation, being conscious that in the combat, environmental considerations are subordinated to the fulfillment of the mission and the preservation of human life, although this does not imply that they are ignored. That's the war. That's the way war is: blood, destruction, and pain. So, as we do not like making it disappear, it's an outstanding and meritorious effort trying to introduce as much restraint as possible to its consequences. Thank you.
Thank you. Monse, I don't know if you have the...
Thank you, Carmen. Good morning, everyone. It is my honor and privilege to be with all of you, distinguished authorities, panelists, colleagues, and audience. Allow me to express deep gratitude to all the participants on behalf of Universidad Carlos III and ICEL. This one-day workshop is jointly organized by both, in collaboration with other institutions, the UC3M World Commission of Environmental Law, the Global Judicial Institute on the Environment, the Center of Studies of International Humanitarian Law of the Spanish Red Cross, and the Normandy Chair for Peace. Inside Universidad Carlos III, this event has received specific grants from the Vice Rectorate for Scientific Policy and the Dean of the Faculty of Social and Legal Sciences. Concurrently, we have received support from the Department of International Law, Ecclesiastical Law and Philosophy of Law, the Francisco de Vitoria Institute, and the Pascual Madoz Institute, where the ICEL's International Secretariat is hosted. Also, I must express our profound appreciation to a series of persons for their indispensable and valuable task: the members of the Scientific Committee, the co-director of the ICEL Secretariat, Teresa Parejo, and the members of the Organizing Committee, Thomas Hansen, Isabel Hernandez, Esther Torrecilla, and Victor Tafur, and also to the audiovisual team, in particular to Susan. This workshop brings together prominent speakers addressing a range of themes relating to the ILC's draft principles on the protection of the environment in armed conflict and related issues, including the special rapporteur on the topic. Panel 1 will address issues of the ILC's draft principles from inside. Panel 2 will look at the environment, peace, security nexus and possible paths ahead. Panels 3 and 4 will deal with some strategic issues which are relevant before, during, and after armed conflict. Panel 5 will look at the incorporation of international law on the protection of the environment in relation to armed conflict. Panel 6 will deal with the rapporteurship of the workshop's conclusions, which will be made public afterwards. The workshop also includes a brief but emotional section before lunch devoted to music and culture in promoting the implementation of environmental laws, during which we will listen to a couple of musical pieces composed by Maestro Amos Chilla, the ICEL's representative for music and culture. All panels are followed by moderated discussions where attendees are offered the opportunity to engage presenters on the themes addressed. The workshop will be closed at 5:20 p.m. Madrid time zone by Professor Nicola Robinson and Antonio Benjamin, Executive President and Chancellor of ICEL, respectively. Be aware that to attend online, you will be able to join the workshop and also to participate via chat through the YouTube channel using two different links, one before lunch and another afterwards. Stay with us. Well, law, science, and politics are key tools to get transformative changes in society and build a better world, to get a better treatment for the victims of war, including the environment. The ILC's draft principles constitutes a significant legal milestone for the consolidation of the international agenda that links environment, security, and peace, and it can be crucial for the progressive development of customary law. It contains principles that should be respected to make progress in this field that lies at the intersection between humanitarian law, environmental law, human rights law, and even criminal law. As we have a very tight agenda and there is no time to lose, I will leave you now thanking you all again for being here.
Thank you. So now we move to the first panel, I think. Thank you very much for being here today.
Dear Vice Dean Carmen Perez Gonzalez, distinguished speakers, faculty members, members of the organizing committee, to all of you, good morning. It's a great pleasure and honor to welcome you to the first panel of the workshop, Protection of the Environment in Times of Armed Conflicts, Assessing Implications of the International Law Commission Draft Principles in Related Issues. The first panel, the ICEL Draft Principles from Inside, is divided in three sections. The first one, Introduction to the topic of protection of the environment in relation to armed conflict, that is going to be accompanied through virtual space by Professor Niloufer Oral. She's the member of the UN Law Commission. She's a professor in the law faculty in the Istanbul Bilgi University in Turkey, and also is the director of the Center of International Law in the National University of Singapore. For her, let's start to see in the video. I'll give the floor again in a virtual manner.
Greetings to all of you. I'm so sorry that I cannot join you in person in wonderful Madrid with dear colleagues on this important workshop on protection of the environment in times of armed conflict. However, I will just send you this video, a very short video, and at least let you know that my thoughts are with all of you. And I also start off by thanking Monsi so much for affording me this opportunity. So I don't think I can underestimate or overstate the importance of the topic of protection of the environment in relation to armed conflict. Indeed, sadly, we are witnessing in real time now the very destructive force of weapons, not only directly on human lives, but also on the flora, the fauna, biodiversity on land, air, and sea that is integral to our collective survival. The work of the International Law Commission began in 2013 and has been superbly guided by my two very dear colleagues who will be joining you in person today in Madrid. Ambassador Marie Jacobsen, who was the special rapporteur until 2017, and then she was succeeded by Ambassador Mario Leto, who successfully concluded the work in 2022, this past session. And I've had the tremendous honor of contributing to this work as well. Both have contributed their extensive knowledge of international law in general and IHL law and environmental law specifically to ensure that the final outcome from the International Law Commission will provide a meaningful contribution to an area of international law in which there was a gap or several gaps. I will only speak quite shortly, but I do wish to say a few words on why I believe the final outcome of the Commission to be so important. International environmental law developed exponentially following two key events: the 1972 Stockholm Conference, and this is the 50th anniversary, and the 1992 Rio Earth Summit, and we are celebrating the 30th anniversary. Concepts such as sustainable development, biological diversity, protected areas, the rights of indigenous peoples and communities, principles of environmental law such as prevention, and many more were introduced and developed during this period of time. However, the law on armed conflict and its relationship to the protection of the environment remains somewhat stagnant, and I'm sure that you will discuss this in more detail during the workshop. As a member of the Commission, I'm extremely pleased with the work that we have accomplished in filling those gaps and really updating the law of armed conflict in relation to protection of the environment, or the protection of the environment in relation to armed conflict, so that it meets the 21st century standards. I believe that the 27 principles and preamble will provide a significant contribution to the progressive development and codification of international law in this very important area, where, alas, we continue to see still widespread destruction of the environment, loss of human lives, and clearly what will be long-term adverse impacts on the lives and livelihoods of communities who are victims of armed conflict. Anyway, I bid you goodbye. I wish you all a fantastic meeting in beautiful Madrid, a city I truly love, and I do hope next time to catch up with all of you. Take care. Bye-bye.
The second topic for our panel will be the ILC work on PERAC. It will be, it's our pleasure to present Ambassador Marja Leto. She's the member of International Law Commission. She's the special rapporteur on this very specific topic, senior expert on public international law, legal service of the Ministry of Foreign Affairs of Finland. It's a great pleasure to have you here. I'll give the floor to Ambassador Marja Leto. Thank you.
Thank you, Mr. Chair, for giving me the floor. And many thanks to Professor Montserrat Abad and other organizers of this timely workshop for the kind invitation to be part of this panel. Speaking after Dr. Oral's excellent introduction to the ILC work on the protection of the environment in relation to armed conflict, I think I will use this time by making 5 substantive points regarding the topic and its final outcome. First, a distinctive feature of the topic is that it's not limited to armed conflicts, but as such, but seeks to cover the entire conflict life cycle, extending from the time before the outbreak of an armed conflict to post-conflict situations. Opting for this temporal scope, which is also evident from the title of the topic, especially the words "in relation to," the Commission has recognized that preventive measures are likely to be the most effective if they are taken before a conflict breaks out. Environmental effects of armed conflicts also continue to be felt in its aftermath, sometimes for decades or longer. And timely action to address them may prevent greater harm and facilitate the transition to a sustainable peace. And let me add that this approach is consistent with the general tenets of environmental peace building. The broad temporal scope of the ILC work means that the topic does not only focus on the obligations of the warring parties, but also seeks to clarify what obligations other non-belligerent states or international organizations may have, and what they could and should do to enhance environmental protection in relation to armed conflicts. The principles do address questions concerning the conduct of hostilities and state responsibility for breaches of jus in bello or jus ad bellum, but they also deal with peace operations, humanitarian assistance, protection of the lands and territories of indigenous peoples, and regulation of business entities. Second, in addition to the three temporal phases, before, during, and after armed conflict, the draft principles cover situations of occupation as a specific type of armed conflict, governed by a specific legal regime, the law of occupation. While the law of occupation, as you know, was mostly codified during the first half of the 20th century, and therefore does not directly touch on the protection of the environment, it has provided a good basis for the Commission to identify the environmental obligations of an occupying power. And why is that? To begin with, the effective control that an occupying power exercises over people and territory entails a broad legal responsibility, including a duty of vigilance extending to private actors. It also means that human rights law plays a particularly important role in situations of occupation. Most of the rules of the law of occupation are, moreover, of a general nature and have proved flexible enough to be adapted to changing circumstances. The Commission has therefore been able to base the draft principles relative to situations of occupation on existing customary law obligations, which have been interpreted in light of subsequent developments in international law. The relevant draft principles spell out the general environmental obligations that an occupying power has towards the occupied population, the territorial state, and other states. Third point, the broad focus of the ILC work has made it necessary to go beyond the law of armed conflict. The draft principles draw on other areas of international law, particularly international human rights law and international environmental law. And we will hear more about this aspect in a short while. I will just say that both these areas of law are obviously relevant in pre- and post-conflict phases, but they also have a role to play during armed conflict, including and in particular in situations of occupation. And let me add that the role of international human rights law is quite interesting in this regard, as the interconnections between the law of armed conflict and human rights law, on the one hand, and human rights law and environmental protection, on the other, have been widely and authoritatively recognized. Examples of principles that draw on human rights law include the draft principles on due diligence by business enterprises and liability of business enterprises, and a draft principle on sharing and granting access to information. Other provisions, such as the one on sustainable use of natural resources and the one on prevention of transboundary harm, both applicable in situations of occupation, rely on international environmental law alongside with the law of occupation. Fourth, no general distinction has been made in the draft principles between international and non-international armed conflicts, even though some of them only apply to international armed conflicts. I should add that this is an aspect that only has relevance with regard to the principles applicable during armed conflict. Most of the 27 draft principles are thus unaffected by the classification of armed conflicts. Several draft principles address relevant actors or parties to a conflict, using notions that include non-state armed groups and take into account, inter alia, that it has been a common phenomenon in recent conflicts that non-state armed groups exercise control over territory and people. Fifth, and finally, while the draft principles cover a broad array of measures across the conflict life cycle that seek to prevent, mitigate, and remediate environmental harm resulting from the conflict, they do not seek to do this in a comprehensive manner. Rather, the two special rapporteurs have identified certain issues that are particularly relevant for the protection of the environment in conflict-affected areas. In this we have profited, and this is something I wish to highlight, in this we have profited from consultations with relevant expert organizations, including the UN Environment Programme, the UNESCO, and the ICRC, and from related research. Obviously, the Commission has also benefited from a regular feedback from states, as is always the case with its work. Thanks to these consultations, the work on the topic has been able to rely on the enhanced understanding of both the direct and indirect effects of environmental effects of armed conflicts, whether resulting from the conduct of hostilities or from the particular circumstances created by and around armed conflicts. As an example, altogether 5 draft principles address the protection of the environment from unsustainable or environmentally harmful exploitation of natural resources. It is well known that armed conflicts in resource-rich countries tend to accelerate illegal and unsustainable exploitation of natural resources. According to the UN Environment Programme, 40% of internal armed conflicts over the past 60 years were related to natural resources. And since 1989, something like 35 armed conflicts have been fueled by natural resources, ranging from diamonds and gold to timber, even coffee and bananas. Mr. Chair, I believe I should now come to the end of this brief overview of the ILC work, which necessarily has also been selected. But I'm happy to note that many of the other issues addressed in the draft principles, such as protected zones, an environmental Martens clause, and remnants of war, will be discussed in other panels today. I thank you for your kind attention and look forward to any questions you may have. Thank you.
Thank you very much, Ambassador Letta. Thank you very much. We will proceed with the third topic, in our first panel, international humanitarian law, human rights law, and environmental law, a complex and interactive approach in the ILC draft principles. This topic, the spokes lady for this topic is Professor Concepcion Escobar. I have the pleasure to introduce her. She's a member of the UN International Law Commission, former head of International Legal Department of the Spanish Ministry of Foreign Affairs, director of the Center of Studies in International Humanitarian Law, Spanish Red Cross, professor of Public International Law in the UNED. It's a great pleasure to welcome you. Please, I'll give you the floor.
Thank you very much. Well, I have in mind that we have a heavy. Now, can you hear me? Okay. Well, I thanks the introduction by the moderator, and I would like to say that, having in mind that we have a heavy agenda, I will not use the time allocated for me for protocol, but at least let me say thanks to ICEL and Universidad Carlos III de Madrid for the invitation to participate in this panel and express how honored I am for sharing the panel with Ambassador Leto, my dear Maya, a wonderful special rapporteur and a great friend and colleague. As the moderator said, reading the title of my intervention, I will focus on a specific issue to which Ambassador Leto made reference before, which is the interactive approach the draft principles follows about some relevant sectors of international law, in particular the law of armed conflicts I would like to follow the terminology used in the draft articles, human rights law and environmental law. For so doing, I will start by some methodological remarks. I will refer after that to how the interaction is reflected in the draft articles, and finally, if some time remains, I would like to mention some substantive examples of this interaction. First of all, I would like to say that for a correct understanding of the normative interaction in the draft articles, it is needed to consider several elements. The most important is that, as the special rapporteur said, the ILC has defined the purpose of the draft articles in a broad sense, built on the idea to consider together two main categories or two main concepts, if you prefer, protection of the environment and armed conflict. Both elements define the purpose of the draft article, which is to ensure and encourage the protection of the environment in relation with armed conflict. As a result, the law of armed conflict, together with some general principles coming from the environmental law, could have been pursued as the core set of rules and principles of international law to be considered at the foundation of the draft articles. However, these two elements are not being sufficient basis to identify the legal framework to be taken into account in the ILC work, in particular because of the new challenges raised by the fact that the Commission decided to work on this topic on the basis of a three temporal phases approach to which the special rapporteur made reference before: the protection of the environment before, during, and after an armed conflict. It was obvious from the very beginning that this temporal approach should have, as a first consequence, the need to examine not only the law of armed conflicts, but also some of the branches of international law, in particular, but not only, the international law of human rights. Of course, no doubt existed about the need to consider the rules and principles of environmental law as one of the essential bases of the ILC work. But the need to take into account those branches of international law was not the only consequence of the methodological approach inspiring the work of the Commission. On the contrary, it was raised simultaneously the need to consider them, all these rules and principles, from a multidimensional and interactive perspective. Even though some criticism was expressed by some ILC members about this multidimensional analysis, and in particular about the interactive approach, the Commission has followed an interactive methodological approach, which is well reflected in the draft principle, finally adopted. By so doing, I think that the ILC has duly put the emphasis in the concept of international law as a complex and coherent legal system, which must be analyzed, built, interpreted, and applied, having in mind at the same time all the relevant rules and principles in presence with regard to this topic, and avoiding for that view, through this way, the negative effect of fragmentation. Let me now say something about the manner in which this multidimensional and interactive approach has been reflected in the draft articles. The relationship between the law of our conflict, human rights law, and environmental law appears in different forms along the draft principles. First of all, the existence of such a relationship is made from our substantive perspective, based on the idea that the existence of a safe environment is a requirement for the protection and full enjoyment of human rights on one hand, and on the other hand, by the assessment that both environment and human rights are exposed to suffer serious damages in relation with an armed conflict. Such a substantive approach is reflected in particular, but not only, in the preamble and its commentary. I call your attention in particular to paragraph 5 of the commentary to the preamble. But anyway, this connection, the substantive approach, you can find some expression of the substantive approach in other parts and other elements of the draft principles. Second, I would like to call your attention on the fact that the existence of a relationship between various branches and rules of international law as one of the methodological pillars of the draft principle, is reflected also from a normative perspective, not only from a substantive perspective. And that the Commission saw that, for example, by the general reference in the text of some draft articles to the, and I quote, applicable rules of international law, or by using the expression under applicable international law, sometimes beside specific mentions to the law of our conflict, in particular in the context of the second phase, so during the armed conflict. Or this connection has been made also by reference to some general institutions of international law related to the international law of human rights, for example, the reference to the indigenous people and displaced persons, the reference to the protection of the rights of the inhabitants of occupied territories or the local communities in any process of reconstruction after an armed conflict, and by making reference to the right to health or to the reparation in several draft articles included in the draft principle. Sorry, I always made the same mistake because I was working in a draft article, and I tend my mind go in this direction. Sorry. Or finally, I think that it is very important to highlight the fact that the Commission make reference to the right of access to information on environmental issues that constitute, as all of you know, a good example of interactive of an interaction between human rights and environmental issues. we can see this kind of interaction or relationships through all the document, not only with regard to the first and second phase, but also with regard during the part devoted to the second phase during the armed conflict, and also with regard to the general principles applicable to all the draft articles. But without any doubt, the place where the multidimensional and interactive approach is best reflected in the draft, in the work of the Commission, are the commentaries, which relevance can be undermined because, as it is well known and expressly said in the first paragraph of the general commentary, the text of the draft articles must be read together with the commentaries. In this context, I would like to draw your attention, for example, to the commentaries to draft principle 3, 4, and 5, in which the interaction among the law of our conflicts, the human rights law, and the environmental law is affirmed. And I would like to mention also the continuous reference to different international instruments devoted to human rights, to environmental law, which is contained in the commentaries as the basis for building the principle or the draft principle, or as the basis for make a correct deep interpretation of a deep principle. However, it must be underlined that even if the interaction between law of our conflicts, human rights law, and environmental law occupies the central place in the draft articles, they are not the only branches of the international law having been considered by the Commission in the context of this topic. Actually, the state responsibility, the responsibility and liability of private companies, and the individual responsibility, the individual criminal responsibility have also been considered by the ILC and reflected in the adopted draft articles. Finally, I would like to make some comments about the criteria under which the normative interaction take place at the draft articles. Of course, the Commission has neither identified nor enumerated those criteria in a formal manner, but it is possible to deduce them both from the draft articles themselves and from the commentaries to the draft articles. Those criteria could be summarized as follows. First of all, the applicable rules and principles of international humanitarian law or law of our conflicts, human rights law, and environmental law coexist in relation with an armed conflict. The decision about which are the applicable rules and principles must be taken in a case-by-case basis, having in mind the phase on which they will be applied. Third, it is possible that rules and principles appertaining to different branches of international law are applicable in a concurrent way and at the same time. Fourth, the law of our conflicts continues to be considered as lex specialis, but only during the conflict phase. And fifth, in any event, the lex specialis character of the law of armed conflict, doesn't avoid the possibility that any other rule or principle of international law was also applicable in this phase. I think that I have used all my time, more or less, so I stop here, and probably we can have the possibility to speak a little bit about some examples during the debate. Thank you very much.
Thank you. Thank you very much, Professor Concepcion Escobar. We have finished these first presentations, and if there are any questions, they're welcome. Well, we are right on time. Thank you very much, and let's proceed to the coffee break, right? Thank you.
But I would like to highlight from the perspective of human rights law. I think that it is very important, the principle related to indigenous people, displaced persons, and also the reference to the duty to repair, to the reparation. I think that there are some elements that are taken from the human rights law sector. Yeah, you know, I think that it is important. If we look, for example, to the commentaries, we can find also a big number of references to the resolutions adopted by the General Assembly, in particular the right to the environment as a basis, the health environment as the basis of the human rights, and which are the consequences, or the reference to different other elements included, for example, in some Maria could make some offer more clear example about that, but the reference, for example, to different bodies, international bodies related with human rights that have been able to define the concept of culture, the concept of environment, always in connection with human rights. I think that is very important. One key element I think is also essential is the inclusion of the duty to share information, which has been included, for example, in the Aarhus Convention or in the Escazú Agreement. Both conventions are not environmental conventions; they are human rights conventions devoted to the protection of environment. So I think that we can find a lot of examples regarding the relationship between our conflict, maintenance of the peace, and health and law of the environment. I think that is important, the reference to the Martens Clause, to which the Ambassador Leto gives some examples, but I think that we can find a lot of examples of how the Commission has taken into account other sectors of international law which are relevant for the protection of the armed conflict, of the environment in the context of our conflict. I think for me, the reference to international, the state responsibility, the individual criminal responsibility, the responsibility and liability of the private companies are very important. Well, the inclusion, the introduction also of the idea of cooperation, the international cooperation, in order to avoid threats to environment in relation to a conflict, but also in order to obtain reparation, even in the situation where the reparation is not is not a duty for the state or for any other international subject. But I stop here because I think that Maya could offer more examples than me.
Thank you.
Thank you. If I may, I would like to draw your attention to the draft principle regarding the general environmental obligations of an occupying power, because this is the one draft principle which relies alongside with the law of occupation also on human rights law, but it's the only one that refers to human rights.
Yeah.
In paragraph 2, where it recalls that an occupying power shall take measures to prevent significant environmental harm, including harm that is likely to affect the health and well-being of the occupied population, the protected persons, or otherwise violate their rights. And the reference to rights here and this is clarified in the commentary, refers both to human rights and the rights of protected persons under the law of occupation.
Thank you very much. Thank you very much. Very enlightening. Thank you.
Everybody, first of all, let me congratulate Monse for the outstanding organization of the agenda of this quite difficult topic that you are addressed from the beginning of this morning, and you will stay here until the evening. Take care with the phantoms. We have a lot in the campus before you leave. I have to coordinate, but not chair, because I have no dignity to chair to these people that is around me on this table. A very interesting round table regarding environment, peace, security nexus, feasible paths ahead. I think that there is a person waiting to get in connection with us, which is Mr. Donald Kanyaru, but I cannot see him in the screen yet. I don't know if it is better to wait for the connection or whatever you like. Well, like while the connection arrives, let me introduce you some of the members of this round table. First of all, my dear Professor Juste Ruiz, Emeritus Professor of the University of Valencia, one of the most well-renowned professors of international law in Spain. And in his curriculum, you can underline that he has not been only involved on academics, which is enough, because the world of international law is always growing, no? You cannot stop, no? But as Spaniards, we have to be very proud, because he has been appointed consultant for the Spanish government before some organizations of the United Nations in matters relating to international environmental law, and then he is included in the list of arbitrators in environmental matters of the Permanent Court of Arbitration of The Hague, and member of the Compliance Committee of the Barcelona Convention and its protocols. The most warmly welcome to this campus, that you know we really appreciate you as a person, as a professor, as a colleague. It's a pleasure to be here close to you, not just coordinating the table, but close to you, Professor Juste.
Yeah,
and
you.
To my right, I have a person that I know for a long time, and with whom I have an outstanding relation. Is an ambassador of the Kingdom of Spain, Ambassador Carlos Fernandez Arias, who is going to address a topic on climate change and security and European point of view. Carlos Fernandez Arias has served in different positions in the ministry, and to me, and please, if you do not agree to me, one of the most important, if not the most important position that he has served is as former ambassador of the Kingdom of Spain before the Republic of South Africa.
That was my last post, yes.
Yes, your last position. So my warmly welcome here to this panel and to this campus. And you know, from a personal standpoint, how much I appreciate that you are here. And I can see myself on the screen and the rest of the members of the table, but not...
He's there. Yeah.
Now.
Ah, you are there. Sorry, hello. Hello, Mr. Donald Kanyaru. Hello, Donald. Can you hear me?
Hello. Yes, I can.
Thank you very much for being here in the screen. Can you hear me?
I can hear you.
Thank you. Mr. Kanyaru is going to address the question environment and peace and the siege. Which way forward? he's also a person that is very much familiar with the day-to-day life of international organizations because he has served as a former diplomat with the government of Kenya and now is the managing partner at Kanyaru and Kanyaru Advocates in Nairobi. Mr. Kanyaru, nice to meet you in the screen, and we hope that the subject that you have to address will illustrate all of us about a very serious and quite complicated matter. My warmly welcome to this panel, Mr. Kanyaru.
Thank you. Thank you.
And last but not least, Professor Romina Pezot.
Yes.
I can introduce you in Spanish if you wish, but no. No, thank you very much. She is a professor at the Buenos Aires University, no? But currently you are doing your PhD.
Exactly. At the Geneva
and you are under the supervision of professors in Geneva, no?
Yes, Andrew Clapham.
You have Andrew Clapham. I know him personally because
Right.
I was with him in Florence. Yes,
Studying
we
there.
were together, yes. And you've got the master's degree in international law at the
In the same institution,
world-reputed,
yes.
Geneva Graduate Institute. So my warmly welcome.
Thank you so much.
Thank you for being here in person. And you are going to address whether occupying powers should take action against climate change during international military occupation. So I don't wish to use much more time. And please, Professor Justi, the floor is yours.
Thank you. I would like to start by thanking the organizers of this timely workshop, and especially Montserrat Abad, for having invited me to that. I'm very grateful to it. It was a poison invitation because it's a hard topic, more difficult than I was expecting. It took me a lot of trouble to go around it. I hope I come out to some conclusions that are positive. Let me check the hour because I have only 10 minutes and I'm afraid of myself talking too much. My presentation is going to be perhaps a little unorthodox in some points, but I'm ready to wait until the colloquium for fighting back. Because I have maybe particular opinions in some things that are commonplace, but I see in different ways. So we can discuss of that if you like afterwards. Well, my presentation is Pax Ecologica, a vision from international law. Is there in the screen for everybody to follow my PowerPoint?
Not yet.
Not yet.
You have to press the link. I'm afraid that it is necessary that Donald disappear from the screen, but we will recover him.
It's only because it will help me to be short. Okay. Can you make it hold the screen? Well, while she's going ahead, I underline my title, Pax Ecologica, a vision from international law. I may have said a vision from international environmental law, but anyway. My first slide relates to the need for environmental peace in connection with the Pax Ecologica title. UNEP has produced in 2021 a report called Making Peace with Nature that takes on some proposals coming mainly from NGOs, ecologists' side, asking for people to stop warring against the environment. The idea is that human persons act as if we had many different environments to utilize one after the other, and if like the environment was an enemy more than a source of life for anyone. So the idea of stopping war against the environment, the Secretary General recently said using the environment as a toilet. I took it from a writing by Montserrat Abad Castellos. Is one of the things. The UNEP report, in my opinion, is somehow misleading or disappointed because in spite of the title, the content goes in the usual mainstream of sustainable development, economic development, no one behind, and things like that, which is most rhetoric and linked to things that is not really what is promised, making peace with the environment or with nature. I think that it's kind of misleading, and it follows the mainstream of the UN thinking on the matter, but not really answers the problem. Another element that goes in the same way is the Agenda 2030 for sustainable development, sustainable development goal 16, this is a mistake in here, is 16, calls for the promotion of peaceful and inclusive societies. In my opinion, this is also a little out of way because inclusive and peaceful societies is always good, but it's mostly a question of national societies than international societies, and it calls for many actions that are very plausible in themselves, but not really linked to the need to environmental peace and making peace with nature, again. And besides, if you read the short content of Sustainable Development Goal 16, it doesn't say much. It's very short, and really you don't find much substance on it. Another line of thinking is living well in harmony with nature. The General Assembly of the United Nations, since 2009 till today, is regularly adopting a resolution on harmony with nature, but still is disappointed because the General Assembly refers repeatedly to some countries, some groups, indigenous people, and some weird groups that are around the world, but not really refers to harmony with nature as a common interest of all peoples and states of the world. Is something that is somehow referred to some civilizations, but not the whole world. It's a little disappointing. And, well, it's also more symbolic than anything else because instead of, or in addition to declaring 22 of May the day of harmony with nature and other things, but promotes activities and studies and recognizes the importance and everything, but not really a hard law content in this successive harmony with nature. And then what is important, in my opinion? Important, in my opinion, is to move from a localistic and selfish vision of the interest of each one, states, to common objectives of the international community as a whole. And this is in the preamble of the ELC's outstanding draft principles that calls for considering the protection of the environment in relation with atmospheres in particular as a common objective of all states and the humanity as a whole. So in this respect, in how to deal with the environment, in the context of peace, the important thing is departing from the old-fashioned visions of national interests. This Edith Brown Weiss has said a long time ago that in the field of environmental action, the vision of national interest should be changed. This is not a zero game, and the purpose of the whole exercise of protecting the environment is grouping the collective interest more than defending each one's national interest, because the environment is not national, is by definition global, and all things are interconnected, and therefore the important thing is consider living in peace with the environment as a common interest to feel. Then, my God, the environment, peace and security in action. Recognition of their mutual linkages is a commonplace. It has been repeated today several times. Already the Security Council Presidential Declaration 1992 said, referred to non-military threats of peace and security as a challenge for international environmental peace. From the field of international environmental law, there had been a progressive call to action, starting from timid reference in the Stockholm Declaration and moving forward in the World Charter on Nature and other documents until Rio 92 Principles 24 and 25, that are still disappointing to me. Principle 24, because it has some inherent ambiguity, and also is linked to protection of the environment in relation to sustainable development. And I'm not sure that sustainable development and the environment are exactly the same things and go in the same direction. And then Principle 25 is just a statement without much legal content. It's just a political, thank you. That even in the negotiations of text of Rio 92 Declaration was not object of particular discussion. It was like a minor element. Okay, so the relationship, the nexus, is a poorly understood, multifaceted relationship that was said by UNEP in another report in 2004. And I should underline the complexity of the issue, that it's affected by a disturbing link with the nuclear weapons issue that has been an obstacle to move forward, to be too much close to the impossible debate on the legality of nuclear arms. And then there is still political controversy as to the definitions, legal scope of the principles relating to it, competent bodies in the nations, in the United Nations, and besides, to deal with the matter. So there is a lot of confusion. And in my opinion also, this is again unorthodox, it's excessively focused on natural resources and sustainable development. This set of documents has too much focus on that. In my opinion, at the end, is an issue more suited for political and soft law approaches than from legal developments. Normative developments, this is my last slide. As you all know more than me, international and humanitarian law, the law of armed conflicts, has a progressive evolution towards including reference to the protection of the environment during armed force. The system has some inherent limitations that I don't remember by heart, but are linked to the idea of mostly relating to international war or armed conflicts and national armed conflicts, principles difficult to manage, and two premises, in my opinion, thresholds for forbidden activities against the environment in relation with armed force or during armed force, thresholds that are impossible to reach, that apply cumulatively, vast, I don't remember the three magic words in English. How are the three magic words of the threshold for forbidden impacts on the environment during armed force?
Sí, cómo tiene que ser el impacto.
Sí, no, pero hay tres
daño.
palabras.
Sí.
Well, I should check on the document that is vast, long-lasting, and
Widespread.
yeah. Okay, so this is an impossible threshold to reach, and in fact, several, but in particular, the report of the prosecutor for responsibilities with regard to NATO bombing campaigns in Kosovo said, don't start the job, it's not going anywhere because it's impossible to in any way demonstrate that the three elements of the threshold are going to be reached. So best forget it than start this. Yeah. Okay. What about this is my last word, about the draft principles of the International Law Commission. I said already it's an outstanding job. All merits shall be given to this fantastic text. There is still some things to think about. I wouldn't say gaps, maybe challenges or elements that need to be reconsidered. And what are those? One is the nature of principles that encompasses both binding obligations under international customary law and recommendatory elements that are not binding under international law. This needs some improvement in real life, because as a statement is good, but how to put it into practice is going to be hard. It integrates international environmental law and international humanitarian law and other sectors of international law, as Concha Escobar has said before. But there is, in my opinion, and this is the unorthodox part of my last word, there is some kind of circular references to applicable law throughout the text that may create some problems. In the problem, the basic problem, in my opinion, is if you are stating principles of international law, both constitutionary and customary and recommendatory, you are stating what it is. If you restate at every time that it has to be applied in conformity, subject to, without prejudice, to applicable law, then this is a little circular. You say what is the law according to the law. This is some contradiction intellectually, in my opinion, on that. And I finish with that. Thank you.
Thank you very much, Professor Fischer. The discussion will be after, no? So now I think it's the time for Donald. Donald, are you on the screen?
We need to turn.
We have to turn off this. Yes. Donald, good morning. The floor is yours. Thank you very much.
Yes. Thank you, Chairman, distinguished panelists, colleagues, ladies and gentlemen. I thank also the organizers for inviting me to this occasion. Then a conflict, whether armed or otherwise, hurts humanity, nature, and woods peace to some extent. The only difference is on the degree of damage. So at any moment, environment and peace are under siege and humanity is threatened. Can conflict of whatever nature be contained, or better, be forever eliminated? Could this be humanity's still unrealized dream? Protection of the environment in relation to armed conflicts has been positively addressed by the International Law Commission in the 7 preambular paragraphs, 5 parts, and a total of 27 principles already introduced and presented by the first panel, and the professor speaking immediately before me. The set of soft law draft fills a gap that has been glaring and imminently increases pertinent principles at the time when the pockets of armed conflicts, internal and external, is a matter of general concern in every continent and region. In fact, no area is unaffected, actually or potentially, and in one region, the conflagration has already adversely impacted across the globe. Such is the extent of threats to humanity, nature, and environment. The draft rightly connects, and the speaker before me has just said, reiterates and respects existing international law, conventions and protocols, and also, roots into customary and international law. That, I think, is what it should be anyhow. In several principles, in fact, from preamble number 7, where reiterated in several principles, the draft obligates, quote, states, international organizations, and other relevant actors to prevent, mitigate, and remediate harm to the environment before, during, and after an armed conflict, unquote. However, not expressly provided is who does the monitoring, prompting or alerting the players on imminent threat or likelihood of conflict arising with consequent injury, damage, and destruction. The text is also silent on the specific roles the players can intervene and be introduced, but can be introduced in binding instruments as they build up. Of course, for any immediate conflagration, the international and security on specific charter organs. On conflicts addressed by the International Law Commission, the lesser than foreseen or to neighbors, both humanity and environment, and survival is at risk. In terms of forward, is the possibility and regional and instrument a conference on the human environment in 1972, and later the 1992 principles and many others which have mothered global international conventions, covenants, and agreements, and followed them through with a series of instruments in practically every region, Western Europe, Latin America, Africa, Asia, and the Pacific, and in instances all the way to sub-regional levels. Professional international non-government organizations like ours, on nature conservation, ICEL, and others, scientific organizations, invariably support states in critical roles as well. These specialized NGOs, if I may term them so, have become protectors of our environment and pillars of peace under the umbrella of international security at the highest level to ensure unequivocal survival of humanity and nature. Should the principles be strengthened into binding law to secure future generations? The parties, if I may call them so, addressed in these principles should not duck their responsibility. They should advance dialogue without delay in evolving binding law. It is true we have been cautious, indeed exercise more caution than concrete action in availing and applying key tools in science, technology, and finances. But we should not relent. Environment, peace, and nature are priceless, and humanity as guardian should be secured for untold generations. Is it time we surprise ourselves as humanity on our resilience in totally unexpected circumstances, in strengthening a new regime, in eliminating armed conflict on Earth altogether? There may be many questions, more questions than answers at this point, but this matter must remain on the table, not under it. The future must thus define and embrace solutions irrespective of whatever the challenges. Finally, as the United Nations and other organs respond to untouched concerns, who, how, when, and on the ground rules, what is missing must be developed and shaped into sustained future. The job has started, thanks to the International Commission, but it is not over. So we must commit ourselves to overcome past centuries of unproductive competition, negativism, jealousy, and avoid senseless war or wars as apparent. What have we learned from the centuries aforementioned? The International Commission has done a commendable job. Let humanity embrace the results, sharpen solutions, and apply them. No more threats to peace and harmony, to humanity and its environment and nature. Wisdom should prevail to channel resources lost into shameful waste and damage as we embrace a glorious future. As I conclude, let humanity radiate peace and embrace unimpeachable security at every level. Respect nature and all creation as the Creator set out and installed the guardians to take care of it. Thank you for the opportunity to make some brief remarks on so important a topic. Well done. Thank you.
Thank you very much, Donald, for your outstanding contribution to the roundtable, and we wait for the discussion time if somebody wishes to to do some questions on the topic. Thank you very much again. Sorry that you are not here in person. Well, and now I give the floor to Carlos Fernandez Arias. He's going to address the topic, climate change and security, and European point of view. So please, Ambassador, the floor is yours.
Thank you very much, Carlos, and thank you very much for inviting me to this panel and this discussion. It was quite interesting I just came back from Africa, and it was quite interesting to see that climate change is affecting security in all levels, community security, frontiers security, etc. If you go to places like Madagascar, you see that climate change is really affecting a country. I was also accredited to that place, also in Lesotho, and in other parts of South Africa. And Southern Africa was not the worst of the continent. If you can compare to the Sahel, what's going on in Central Africa, etc., etc. Climate change is there, and climate change is important, is really affecting security in most parts of the world. What was the EU response to that problem is what I'm being asked to discuss and to present to you. The EU earlier, as in last January 21, agreed some conclusions of the Council on climate and security. The EU recognized that the climate change is a menace, is a threat to stability and international security. Clearly, it is a clear threat to stability and security, because it put pressure to ecosystems that we haven't seen before, because it's a threat to food security in many parts of the planet, because it provokes local conflicts that may develop into wars, because is also triggering the moving of people from over borders in many other places. Those conclusions also reiterate the importance to link security and defense to policies of preserving the environment, which is very important idea in that sense. And also decided that they have to and the EU have to work together with the different organizations, international organizations, not only the global ones, but also the African ones in particular. Few months later, in October, from those conclusions of the Council of January 21, the Council approved a concept for an integrated policy about climate change and security. That was the 5th of October last, in 21. And it stressed again the very short link that exists between the climate change and the security, and the need of an integrated policy to tackle both. It mentioned a few examples that were triggering concerns. For instance, the region of the Chad Lake, which is really drying up, or the Aral Sea in Central Asia, or the Arctic, for instance, which are main elements of concern because of the fast speed that change is taking place in those areas. So what the conclusions of October decided is that to put into the European agenda two elements that should have some priority. Firstly, the European Green Deal, which is considering climate as a threat multiplier and therefore a source of conflict. Work on resilience and try to avoid displacement of people. if you look at the Africa example, you are going to see that many of the, or most of the internal displacement of people from different countries is really due to that, to the scarcity of water and scarcity of agricultural land, etc. And the second idea was to approve an integrated policy putting together economic change and security and climate change. It was decided that the climate change deterioration of the environment is increasing and is going to continue increasing migratory displacement, and this migrant displacements is going to trigger and is triggering already violence among different communities and even between borders in many places. So there is a very fast increase of violence and hostilities due clearly to the change of to the climate change and the problem of environment. At the same time, the EU trying to solve problems more directly in areas like Africa or other not less developed areas like Central Asia and others, is to try to put forward some transition elements that could help those areas just to fight better against the climate change and to favor or strengthen also new economic areas of activity that could help development in that sense. That is what the EU has said. Since then, there has been a number of initiatives from different countries. There's a German and Danish non-paper, for instance, that try to put climate at the heart of the EU foreign policy. It's quite interesting because they really define the challenge of the climate change as the most important challenge to humanity that is happening in those days. They want to create a group of friends with a very ambitious agenda in order to help to overcome those threats. They wanted to create a work plan. They put some ideas. I mean, the documents are public, so you can download them if you want from the pages of the EU. And what is important is to put climate change as a threat in all policies that the EU is going to be adopting, not only in security but also in the economic development, etc. That is one is doing. What is interesting is that this idea is not only triggering new initiatives from member states of the EU, but recently there was also a statement from NATO in that sense, which is the very first time that NATO is talking about, or so clearly about the threat that climate change is posing to humanity. Well, there is no clear solution to all of these problems, but at least we can see that there is a reaction, a clear reaction in paper, in black on white, in order to stir the policies of member states, European member states, and to tackle in a very serious way what we are facing. Thank you.
Thank you very much, Ambassador. Straight to the point, on time. And now, please, you wish to change the
just
place
because of the PowerPoint.
She needs to use the computer. So thank you. Now, she will be sit there and It's a swap, you know.
Sí, sí.
Sitting swap.
Sorry.
No, it's okay.
So, as we said before, Professor Petzot is going to talk about whether occupying powers should take action against climate change during international military occupations. Yes. Muy bien.
Hello everyone, I hope all of you are doing well. Thank you. So thanks so much to the organizers for the hard work that you have been doing, and also thanks to the previous panelists for the food for thoughts. And I would like to share the next 10 minutes. I would like to speak about the interaction between ICEL and the UN climate change regime, in particular about the possible extraterritorial application of the UN climate change regime by occupying powers during belligerent occupations. In other words, about the application of the UN climate change regime during armed conflicts. We know that the International Law Commission has been clear, crystal clear, that in general international environmental law continues being applied during armed conflicts. However, why I would like to insist in confirming the permanent application of the UN climate change regime during armed conflict, regardless of the context, regardless if it is times of peace or times of armed conflict. And I have two reasons for that. The first one, from a legal perspective, we can agree that the UN climate change regime is silent about the scope of application. And besides, the ILC draft principle nowadays is a soft law document. Although the content is based in customary law, the instrument itself is soft law. And besides, from a political point of view, I think that it is on point to cite or to quote Professor Simi Payne, who recently in Oslo, in the UC3M International Environmental Conference, she mentioned that the environment is always marginalized as soon as a commercial or security interest appears. And I think that a good lesson or example of this marginalization due to security reasons is the advisory opinion of the ICJ on nuclear weapons. I think it's a good example of this lethal combination, let's say, between legal silence and realpolitik, in the sense of the negative impacts that it can have in the protection of the environment. For that reason, I think that if we consider that any armed conflict for sure is going to threats the security of those countries involved, and at the same time, in any armed conflict, the greenhouse gases skyrocket, I think it's a good reason to not leave a space for a state for invoking or saying that the UN climate change regime is not applicable during armed conflicts. So, for that reason, I think that we should foster the application of the UN climate change regime regardless of the context, and for that I have three reasons. The first one is the object and purpose of the UN climate change regime. Just by remembering the objects of the regime, I think that we can conclude that the regime is a planetary risk management treaty. This means that deals with a global, serious, long-term environmental problem. And this means that this problem related with the Earth climate system is challenging the traditional dichotomy of public international law and its branches about being applicable only during peacetime or only during war times. And this challenge is proposing to replace the word "or" by the word "and." This challenge is proposing to apply permanently international law, and in this case, the UN climate change regime, because the permanent application is related with effectiveness. And in this case, and connected with this problem, effectiveness is connected with survival of humanity or living entities. The second reason for the permanent application of the UN climate change regime is what I call the extraterritorial application of the regime. We know that this regime is based on a territorial or greenhouse gas production-based system, according to which the greenhouse gases are allocated to those states in whose territories the emissions are generated or allocated. And a good example of this is Article 3 of the Paris Agreement that establishes that the state parties have to present regularly their nationally determined contributions. When implementing this obligation has to be implemented having in mind the prevention principle. So if we combine both obligations, the consequence will be that nationally determined contribution must include the greenhouse gas emissions from those territories under the effective control and jurisdiction of state parties, as it is the case of occupying powers. The third reason is what I call the state parties approach, and is basically connected with respecting and applying international law in good faith. So if only the occupied power is party to the UN climate change regime, the occupying power will have to respect this regime because it's part of the local law, because according to ICEL, the occupying power has to respect domestic law. And the other way around, if only the occupying power is party to the UN climate change regime, will have to respect because of the extraterritorial application reason that I explained before. So I'm only sharing these three reasons to support the permanent application of the UN climate change regime during both type of contexts. And for sure, most of you have heard this famous phrase that is an old one, that in times of war, law is silent. I think, and I would like to connect this old phrase with something that Yuloma Slade said, that silence of conflict links from international environmental law does not mean silence from ICEL, in particular when climate change law and international humanitarian law share the same humanitarian concern. If we have in mind that international environmental law plus UN climate change regime plus international humanitarian law are not dumb or deaf, I think that this is the momentum for demonstrate that public international law and its branches are not silent during armed conflict, and I think that the UN climate change regime can also contribute or be an instrument for peace. Thank you.
Thank you very much for your speech, and it has been really quick. And well, we don't have time enough to have a discussion of about 10-15 minutes, but I think, please correct me if I'm not right, that we have 5 minutes, mostly regarding the people that are connecting through streaming. Is there anybody on the other side of the screen that wishes to put a question to whatever of the members of this round table? They are here. Yes, I can see that there are some people there. Please. No. Some questions? Well, while we are waiting for these questions, we have people here in the room attending in person the discussion. So if anybody wishes to put a question, it's warmly welcome. No question? Yes, there is one question from the ambassador. Thank you very much.
Thank you very much. Just in case there are no questions.
Please, it's a microphone for you.
I would like to, thank you, add something to the very interesting interesting remarks made by Professor Puste-Ruiz regarding the normative nature of the ILC draft principles. If you allow me to say first that the fact that the draft principles contain those that reflect existing customary obligations and those that contain recommendations for progressive, meaning gradual development of international law. That, of course, is not surprising as it is in line with the dual mandate of the Commission, and I would say that most of the Commission's final outcomes contain both progressive development and codification of international law. But the more interesting point you made, and I think it's really intriguing, is concerning the references to applicable law. And there I would like to offer a brief explanation. When we are speaking of progressive development, the situation is not as clear as it is with obligations under general international law. Obligations under general international law within the draft principles contain, for instance, the prohibition of pillage, the draft principles applicable in situations of occupation, the Martens Clause, the basic principles of international humanitarian law. They don't raise a lot of questions. But then when it comes to progressive development, you may have a situation and those situations are not as clear because we are speaking of treaty-based obligations, meaning that all states do not have the same obligations. It may be that a treaty like Additional Protocol 1 has been ratified by the wide majority of states, but it's not universally ratified. That's a problem of membership. Then it may be, for instance, in draft principles related to remediation, that you have different treaty obligations under disarmament treaties, human rights treaties, environmental law treaties, and so on and so forth. And therefore, it's very difficult to consolidate different existing obligations in one wording, and therefore the Commission has found that references to applicable law are quite handy. But I do take your point, and the only thing I can add is that the commentaries try to explain some further clarifications. Thank you.
Thank you.
Thank you very much, Ambassador. Please, Professor Juste, you wish to...
Yes. I only have to thank you for your comments that are fully correct. I was trying to raise some points that could be debatable. As to the principles, you are fully in line with what it is, so thank you for your clarifications. And on the other problem as well, it has to do with the theater, the scenario that the International Law Commission faced with countries, big countries that attach only to their own conventional obligations, nothing else, and you have to deal with that. So you have to make concessions, and one concession is at points where there is a deep misunderstanding, there's adding in conformity with applicable law. It's all correct, but it only sends the problem to the future. When you face one element, in fact, that raises this point, the problem will come out again. So the International Law Commission went as far as it could possibly go, and with a very constructive spirit and a marvelous drafting technique. But the problems are there, and sometimes they are more conspicuous or insidious than they seem. But I agree with your interpretation, it's very good.
So thank you very much. If there is a question from the General, please, General. Thank you.
I want to just to take the opportunity of some words of Professor Romina Pissot.
At the microphone, sorry. They are asking for those online.
Okay. Thank you. You said that during wartime law remains silent.
Yeah.
That made me remember some very ancient words of a Roman general, General Mario, that he said that the noise of the combat of the war didn't allow him to hear the noise of the law. He was right, I think, in some reason, because this was a question of he gave the Roman nationality to his combatants who were not Roman citizens. But taking it to the environmental issue, I think at least that in NATO environment we have at least now at least 5 standardization agreements that apply to different scopes on environmental issues during combat or preparation of operation, or even during peacetime. And here in Spain we have just produced a national rule, a national standard operating procedure that guides all the process from peacetime to combat time to conduct and to adopt environmental consideration. So at least I think that we are able now to hear the noise or some noise. For sure there will be a lot of way to walk, but
it's true.
I think we have opened our ears.
Yes. Thank you so much for your comment. Yes. Can I? Okay.
Please, of course.
So this topic is part of my PhD thesis. So when I was thinking about arguments, etc., I have realized that sometimes we give for granted the application of law, etc., and I think that taking into account the advisory opinion and how realpolitik and the influence of security, etc., it has a role that is playing and influencing the application of law. And as we know that sooner or later there is a group of states that will ask a new advisory opinion to the ICJ related with environment and climate change. So for that reason, I think that as lawyers, we have to start thinking or producing arguments to support the permanent application of these regimes, just to avoid having another advisory opinion with the conclusion that the ICJ gave in that moment, even though I know that in that moment in 1996 there was not any a specific treaty prohibiting nuclear weapons, but yes, we had in that moment many international rules that maybe could have helped to arrive to a different conclusion if the influence of some states could have been different. So for that reason, I think that as academics we have to propose new arguments to start preparing if that happens. Thank you.
Thank you very much. Thank you very much for all your contributions. And now the floor is for the next roundtable. Thank you. Goodbye.
I work in human rights, international humanitarian law, and sustainability question. No? It's a pleasure and an honor to be here and to moderate this panel dealing with certain issues in unarmed conflict and to introduce people of such knowledge and prestige. No? Questions that reflect the progressive development of public international law. This address new looks on unarmed conflicts different from classical views. The international community entrusted the International Red Cross Committee as a guardian of international humanitarian law. The International Committee has always sought to adapt its action to the latest development and has made practical proposals for the improvement of humanitarian law. On the other hand, the codification process of international law in New York by United Nations, in The Hague, and Brussels law in humanitarian law is completed very recently with new concerns and new developments. In addition, there is the question of indigenous people with a worldwide a conception of life and rights more connected to nature. The subject matter, the focus of this roundtable, is the protection of nature and environment before, during, and after an armed conflict. To talk about these things, we have in this seminar the best specialized in humanitarian law and indigenous people. First of all, Professor Karen Hulm will intervene to speak on international law and the issue of environmental areas protected. International humanitarian law is silent about this. Thus, the inclusion of two new provisions for such space in the recently adopted draft principle on the protection of the environment in relation to armed conflict is a milestone achievement. Professor Hulm is Professor of Law at the School of Law, University of Essex, United Kingdom. Karen is specialized in the legal protection of the environment in relation to armed conflict. She has also published on environmental human rights, environmental security, post-conflict obligation, the legality of a specific weapon, as well as climate change, biodiversity, nature protection, ocean and protected areas. She has served as chair of International Conservation Nature. No? Sí. Karen has also worked with the SS Business and Human Rights Project, no? And she has a lot of merit, no? Professor, you have the floor. Thank you very much.
Thank you. Thank you to the organisers, to Monsi, to the university, to Carlos and Thomas. Okay, I will be speaking on protected areas or zones, but on the issue of using maybe international environmental law. So first of all, very briefly, an outline explaining, first of all, I will, thank you. First of all, I will explain the concept of protected areas, how they are harmed in armed conflict, and then I'll move on to international environmental law, or IEL, for the abbreviation there, before and after conflict, and then the important aspect of during conflict. So first of all, what are protected areas? What do we protect and why, and what is their value? There are many different types of environmental protected areas. I don't have the time, obviously, to go into this, ranging from small local parks to nature reserves and wetland habitats housing endangered and migratory species, and potentially irreplaceable mega diverse ecosystems such as the Amazon rainforest or Great Barrier Reef. There are, of course, many areas of great ecological value that are not currently protected under any form of protected status. We're looking particularly, I think, though, at things such as special habitats and biodiversity-rich or fragile ecosystems. Some of the key designations are listed on the slide, including, I want to emphasize, indigenous lands. We need to think about those. As an indicator of such criteria, the CBD, the Biodiversity Convention, for example, includes ecosystems and habitats containing high diversity, large numbers of endemic or threatened species, or wilderness, which are areas required by migratory species, areas of social, economic, cultural, or scientific importance, or which are representative, unique, or associated with key evolutionary or other biological processes. And all such areas are clearly going to be pivotal to ensuring biodiversity, as we're currently facing the quickest loss rate to species in history. The most relevant regimes, again, are on the slide: the Biodiversity Convention, Ramsar Convention on Wetlands, the CMS, which is the Migratory Species, and CITES, which is the trade, but particularly on endangered species, and regional instruments too, such as the Berne Convention for Europe, African Convention, etc., etc. And there are national level, of course, designations, such as indigenous peoples' lands. I think it's also worth mentioning, just leaving it at this point, but mentioning the area of Chernobyl, areas that we don't think of specifically as biodiversity rich, I want to say, but where there's been a previous toxic incident and it's created a protected area for a very different reason. Very quickly, why do we protect them? So it's worth mentioning that states have already recognized specifically in the World Heritage Convention and the Ramsar Convention that such sites are of outstanding universal value, and the loss of wetlands, for example, is irreparable. Nature conservation treaties also recognize not only the anthropocentric, so human-based basis for protection, but also the intrinsic value of nature. So what happens to those designations and protections once conflict breaks out, and what are the impacts that we need to be concerned about during conflict? So I'll briefly look at some issues before moving on to the international environmental law. First up is what happens during conflict. I want to hone in on the last two impacts specifically, leaving out mention of when the environment or the protected area is a military objective itself, or it contains one or is nearby to one. So leaving aside the rules on things such as distinction, proportionality, precautions, Articles 35 and 55, etc., etc. I want to hone in on the governance deterioration or vacuum in protected areas. So the general lack of continuation of conservation and the potential influx into the area of IDPs, so displaced persons, or other civilians who need, for example, to feed themselves, their survival needs. We tend also in these areas and these times to see a lot of looting and killing of species and rangers, and looting of the equipment of conservation, such as monitoring stations, their vehicles, tools. We also see the governance of parks being impacted, for example, by lack of finance, but also lack of people and equipment. The environmental footprint of war, this concerns the general environmental damage that protected areas get from having troops move across them, their heavy vehicles, for example. So in addition to dropping bombs and laying landmines, for example, in protected areas, there are also these additional dimensions to which international humanitarian law does not necessarily apply. So, first of all, what are my thoughts on what international environmental law can do? IEL treaties are primarily made for peacetime, so they have enormous value, in my opinion, in building up the resilience of the environment through ensuring diversity in peacetime, so that when conflict happens, the environment is as resilient as it can be. I find that the international environmental law tools are one of the most useful features to trying to limit the impact of armed conflict on the environment, such as the impact assessments, financial and technology transfer, the education, training obligations of states. Training, for example, would be useful generally for the local population, but also the military and park rangers. Monitoring obligations, and then things such as the advisory missions that the treaty bodies can put into place if there's a conflict, for example, but also pre-conflict in giving advice and training. So most important, I think, are the obligations of planning and designing protected areas, which should also include issues such as connectivity of environmental areas so that species can move between areas in their habitat during conflict. And very quickly, post-conflict, clearly post-conflict observance of IEL will help with recovery and rehabilitation of damaged environments. All the tools are there for that, and issues of course of compensation could be covered. Okay, so moving to armed conflict. IHL, humanitarian law, until recently had no provision specific to protected areas during armed conflict. I will only cover Article 60 and the new draft principle of the International Law Commission, which is named at the bottom of the slide. You don't have to read all that, but IHL allows for what are called demilitarized zones to be created under Article 60 of Additional Protocol 1. Key issues are it needs to be by agreement between the parties to the conflict. Designated demilitarized zones generally benefit from being declared off limits to military operations, including by the defending party. Being off limits could be particularly important to help maintain conservation activities in protected areas, as it would help remove the threat from the destructive effects of what I call the footprint of conflict. But I'm not sure if Article 60 has ever been used to protect environmental areas. Key issues on the slide are the need for agreement or an express agreement. The issue right at the bottom in paragraph 2, that they should be defined and describe as precisely as possible the limits of the zone and the methods of supervision. Oh, so protected zones then. So when the International Law Commission, in its draft principles on the protection of the environment in relation to armed conflict, which we've heard a lot about, adopted two provisions, the second of which is draft principle 18 on protected zones. So draft principle 18 is the key provision. It mirrors the demilitarized zones approach for protected areas, setting up a requirement for an agreement between the parties to the zone, to zoning the area, This is undoubtedly a milestone achievement. Such a provision was debated for inclusion in the 77 Additional Protocol 1, but was rejected. So I'm briefly now going to examine the IEL angle. So first of all, which protected areas to include? DP18, as I call it, refers to an area of environmental importance. This concept does not have a fixed definition or criteria and therefore is flexible, although invaluably the international environmental law treaties clearly provide us with a range of criteria on which to select such areas. So it's going to be up to the warring parties what they include within the concept. They will undoubtedly need to be strategic about those designations. I suspect too wide an area will risk reaching any agreement at all. And the location of a proposed protected area or zone will clearly cause problems when it is near to the contact zone. And so I think there'll need to be constant review in case those areas, for example, suddenly become strategically necessary, or at least obviously to move troops through. So I think they'll need to be flexible for renegotiation. What considerations or terms might be in such agreements? Clearly the zone can't house a military objective. The area needs to be off limits to military operations, both offensively and defensively. Being off limits, as I say, would reduce the potential, contamination from weapons debris and mines, but pivotally it would also mean, and I think importantly here, it would also mean that it may attract civilians or IDPs. Wow. So I propose the agreement should cover both of all of those issues and be a sort of mixed area, fencing off hopefully the environmental. How to create them in 1 minute? Clearly there are numerous designations under the treaties. We need an express agreement in very little time. Can the World Heritage Convention regime achieve this? Can that designation be moved across to armed conflict? I think no, it can't be moved directly across to armed conflict, or not at present. I think it would require the treaty bodies and states to agree to add that dimension, and I think it would need to, all those currently in place would need to be redesigned. Clearly there's lots of criteria though that is there for designation. So all the international environmental law issues I mentioned before, the criteria, the geographical area is a great starting point. I'm there almost. But I think key for me is that these environmental treaties can create a platform. And they can include, again it might need amendment, but they can include the requirement that states think about this issue, and it can create that platform for dialogue. It wasn't my idea. I have to credit it to a guy called Adrian Gosside. There might be a good range here for 2 or 3 local states to get together to decide on what would happen between them if there was conflict. We already have the designation of peace parks in some areas. That could be, again, a good starting point for dialogue and thinking about how those protected areas might continue during conflict. Thank you.
Thank you very much. Thank you very much, Karen, for your excellent presentation. In second place, Ellen Obregon, the second, will intervene from the perspective of the International Red Cross Committee. She has served as legal advisor in the legal division of the International Committee of the Red Cross in Geneva. Her present work focuses, among other issues, on the protection of environment in situations of armed conflict, and she is one of the authors of the International Red Commission guidelines on the protection of the natural environment in armed conflict. released in September 2012. Before joining the committee, she worked in British Red Cross project on customary international humanitarian law and in organizations including Oxfam, Trial International, as well as the International Cooperation Agency of the Colombian government. Helen holds a master in Geneva Academy of International Humanitarian Law and Human Rights and a Bachelor of Science in Foreign Service from Georgetown University. Thank you very much. You have the floor.
Thank you very much, Carlos, and also to the organizers for this excellent conference and for inviting me to be here today. So it's really a pleasure to be able to talk about the ICRC perspective on this issue of protected areas and protected zones. And I'm very happy to follow from Karen, who gave you sort of the broader overview and also the international environmental law framework. So I think, it's this one. So without going into more detail on this, I mean, I think we all know of the effects that armed conflicts can have on the environment generally, but also more specifically on the types of areas that we're talking about. It's also an issue that has been gathering increased attention. The ILC draft principles, as we just heard, have two draft principles specifically focusing on this issue. And of course, UNEP, IUCN have also made such calls in the past. For the ICRC, the issue of establishing territorial protection applicable to fragile or important environmental areas is something that we've been recommending since 2010. And it's really about the need, and I think Karen's presentation also showed this quite well, to take preventive action to ensure better protection once a conflict breaks out. And here, the identification and designation of areas of particular environmental importance or fragility as protected zones is also one of the key recommendations that we made in the 2020 guidelines that Carlos just referred to and that I will talk about later today. So most of these initiatives that I've just mentioned, the ILC draft principles, the guidelines, are recent. But as we heard, the idea is certainly not new. There have been several proposals to do this. Karen mentioned already the diplomatic conference to negotiate the additional protocols, which called for the introduction of an article that would grant additional protection to publicly recognized nature reserves with adequate marking and boundaries declared as such to the adversary. So of course that did not make it into the additional protocols, but it's also something that we have recommended, and I said before, I think 2010, it's not true. We also thought about including this in the 1994 guidelines, which was the precursor to the guidelines that we have heard about. The reason it wasn't included in that initial version of the guidelines was really because it was felt that this needed to be set out in further detail. And so it wasn't a reflection of it not making sense. It was actually a reflection of we need to think about this issue carefully. So where does this leave us today? Where do these different initiatives leave us? As we heard, international environmental law provides a framework and a key reference to look at this issue. And I really want to focus now on some of the international humanitarian law rules and that framework. And to share some thoughts on three key questions that we think need to be addressed in looking at this issue going forward. So to start off, and to be very clear, there is no specific rule or no general rule even of IHL that provides protection to natural areas as such. That doesn't mean that they're not protected. And here, what I would like to say is really that one way in which enhanced protection against the effects of hostilities could be conferred to certain environmental areas is by designating them as what we call protected zones, generally speaking, under IHL, and perhaps more specifically and and you see it on the slide, demilitarized zones, and Karen already referred to this a bit. So under treaty and customary IHL, there are several types of zones that benefit from special protection, again, commonly referred to as protected zones. The initial purpose of these provisions is really to protect people. So it's not about the environment. But what we see and what we believe is that such zones could also directly or indirectly confer protection to certain environmental areas. So there is no general IHL obligation to establish these. Their creation depends on the will of the parties to an armed conflict. But once established, they do benefit from specific protection. In particular, on the demilitarized zones, which is a subcategory of these areas, Karen already mentioned it's by agreement, and under certain conditions, if some conditions are met, they cannot be occupied or used for military purposes. And concretely, what this means is that parties to an armed conflict, but even a state unilaterally, not by the terms of the provision, but they could decide unilaterally to also designate or at least identify such areas and try and say we will not include military objectives within these zones, even in peacetime. Essentially what that would do is exclude armed forces and military equipment from the zones, and the zone could only be attacked if they contain a military objective. So that second part, of course, is subject to the agreement of the parties. The fact that a given state does this unilaterally does not then guarantee that the zone would be protected, and that's where the agreement comes in. And these types of agreements can be negotiated directly through intermediaries. And importantly here, and I think Karen also covered this, they can also be established in peacetime, and actually it would be preferable for that to be the case. Of course, this raises a lot of questions, challenges, including precisely that an agreement has to be reached. And here I think is also why we are emphasizing the importance of thinking about this before a conflict happens, and things become much more difficult. But maybe to look at a sort of a second set of obligations that are obligations under IHL, they already apply to protected zones or protected areas or whatever they're called, under Ramsar, under the World Heritage, under whatever sort of convention we're talking about. The natural environment, including these areas, are civilian in nature, and through that stems more general protection of IHL. And I won't get into too much detail because it's something I will also talk about later. But basically, IHL requires that constant care be taken to spare the natural environment in the conduct of military operations. And it also requires parties to take all feasible precautions to protect the natural environment under its control against the effects of attacks. And the designation of areas as demilitarized is one way, among many others, that states can actually take to precisely comply with these other existing IHL obligations that they anyway have to comply with. And just going back a bit to the question of what a system of protection could look like, here I think guidance could also be drawn from the existing IHL framework on the protection of cultural property. Of course, it's to protect a specific set of civilian objects that constitute cultural property. But under that system, cultural property of special significance for humanity is put on a list, and parties concerned undertake never to use it for military purposes or to shield military sites. So there's no such equivalent, as I said, for natural areas, the natural environment, but there are similarities that could be further explored. So to close on some key questions that we'll need to look at in thinking about how to and if we can operationalize protected zones. First, which types of areas should be granted additional protection? I think Karen here covered it quite well. In order for such a system to be feasible and realistic, there has to be a certain selectivity when choosing the areas that would benefit from enhanced protection. Otherwise, this wouldn't be manageable in a situation of armed conflict where, of course, there are military considerations to take into account. And here a range of existing resources from international environmental law and others, the conventions that have already been mentioned, can help to identify what types of areas we could be talking about. Second, what kind of protection could be conferred? So we have the demilitarized zones framework, we have the cultural property framework. All of these can provide elements of what we actually want to do in terms of protection. So for instance, do we fully demilitarize? Is that the aim? Do we go beyond that and try to have also a conservationist approach? Would it be enough, or would it only be feasible to perhaps list the areas, to have very clear criteria on what the areas are, and then for this information to be shared between states and warring parties so that they take it into account in military operations without necessarily going the full way of demilitarization? It's some of the elements that can be considered when looking at that question. And last, how can additional protection be confirmed? And this is really a question of process. Karen mentioned whether we can use international environmental law frameworks to do it. That's one venue, but there might be others. Is it a declaration between states outside of these frameworks or taking into account these frameworks? What actors need to be involved? What are some of the questions we need to ask? So it's really about the process. How do we do it? And they're all open questions, which we see really as a space for humanitarian, environmental, and military communities to come together to explore the challenges and opportunities that conferring such type of territorial protection could bring in armed conflict. So really a scoping exercise and something that needs to be done with all relevant actors. Thank you.
Thank you, Ellen, for your presentation, Estela. And now, in third place, Professor Lieselot Bian. She is on the screen. In Nepal, no? She's in Nepal, but she is by... you can look on the screen, no? Professor Lieselot Bian will intervene on the subject matter nature and indigenous people in conflict and post-conflict scenarios. She is coordinator of the European Research Council Project Rivers. As anthropologist, she is specialized in environmental questions and indigenous people at the University Carlos III. She is member of Instituto de Derechos Humanos Peces Barba and of the Social Science Department. You have the floor. Thank you. Yes, hello.
Okay, thank you, Carlos. Just wanted to check if you can see the slides and if can you hear me well. And if you can see the slides moving, if someone could confirm that, that would be great.
You can start your presentation, Lieselot, Professor.
Okay, okay, thank you. Just put in the chat if the connection falls out, because as Carlos mentioned, I'm in Nepal and I'm using the data of my phone because the Wi-Fi is very unstable. So I hope that the technologies will work in this presentation. So first of all, I wanted to thank Montse and also Thomas for this very kind invitation to be here. Unfortunately, I cannot be in person, but I'm joining you from Nepal, and I'm especially excited to be in this workshop, as it is indeed a very timely and a very complex issue to talk about. And as Carlos mentioned, I'm an anthropologist. I'm based at Carlos Street, the university, but I'm based at the other side of the street in the Department of Social Science. So this is I'm very grateful to Montse to open up the International Legal Department to social scientists. And as you can see in my title, I have put nature in between what they say in Spanish, entre comillas, because in the next 10 minutes, I would like to share a bit about why we should not take for granted the concepts of nature, environment, ecology, and territory. And as I'm an anthropologist, we always position ourselves. So very briefly, I'm originally from Belgium. I'm Flemish. I present myself as an anthropologist, but I have a PhD in law. And as Carlos mentioned, I'm the principal investigator of this ERC starting project called Rivers, Water Human Rights Beyond the Human, Indigenous Water Ontologies, Pre-Legal Encounters, and Interlegal Translation. And before sharing a bit more about my own research, I would like to share with you that I'm currently co-editing with two colleagues, with Peter Doran from Belfast Law School, the Queen's University, and with Jonathan Lelyblad from Australia, the special issue of the International Journal of Transitional Justice, with the title very connected with this workshop, Transitional Justice and Nature, A Curious Silence. And we are currently reviewing all the articles, and we hope to have the special issue published by mid next year. And hopefully our special issue will complement and support and the current debates about the place of nature, environment, ecology, and post-conflict processes. So indeed, I am in Nepal for the project. We had to postpone the fieldwork because of COVID. And the Rivers Project, which is focused on the question to what extent international human rights law can come to grips with pre-legal water realities, we are looking into Nepal, Guatemala, and Colombia as research sites. And the connection between these three countries is indeed that there are three post-conflict countries where the majority or a large part of the victims has been indigenous peoples. In these three countries currently, a lot of indigenous communities are facing the impact of extractive industries like mining, oil extraction, hydropower project. The project Rivers is focusing on hydropower projects. And at the same time, these indigenous communities are also dealing with the impact of climate change. So what we are looking at and explaining or sharing a bit my own journey, and we as anthropologists, we love narratives and stories. So where does this river project come from, and why do we question the concepts of nature and environment and ecology? Is when I was doing my PhD research in Guatemala and between 2006 and 2010 about the impact of the genocide, and mainly about how indigenous survivors were looking and understanding the key concept of transitional justice, which is, as you probably know, justice, reparation, reconciliation, memory, etc. I learned back then that the impact of the armed conflict was not limited to individual humans, but also to the collectivities of the communities, and also what they explained to me, to the sacred mountains that were destroyed during the conflict, or the river, the living being, a living mother, the river that has to swallow up all the bodies, the dead bodies of the massacres caused by the armed conflict. So back then, I already learned that the impact of the armed conflict goes beyond the human. However, back then in the early 2000s, that kind of narratives that questioned the anthropocentric dogma of the human rights of transitional justice was not really, let's say, received in a positive way by my human rights colleagues and transitional justice scholars when we were debating the impact and the role of transitional justice, etc. This has been changed, as you probably know. recently. So back then I was able to publish all these questions and all these other narratives and narratives that question our Euro-Western legal foundations of many of the key concepts within human rights and within transitional justice. However, that was mainly in the field of anthropology that there was openness, and much less in the fields of transitional justice and human rights. As I mentioned, this has been changing a lot, which is, as an anthropologist, very pleased to see. Many times in social science, the law field is seen as a really hard rock science, which is difficult to transform. But I think that we have to be very positive and very open, and to realize that even the law field is also flexible, is also transforming, is also questioning its own roots. And since 2017, I've been collaborating with Belkis Izquierdo, who is currently an indigenous judge in Colombia in the Special Jurisdiction for Peace. And some of you might know that in Colombia, this peace tribunal in 2019 recognized the territory as a victim of the armed conflict. This has been creating a lot of debate, a lot of questions, because indeed, normally the victim of an armed conflict is the human and not an indigenous territory, or not a territory as perceived by indigenous peoples. If you are interested in this kind of debates, Belkis and myself, we have been in an ongoing dialogue since 2017. We published a short piece about decolonizing transitional justice from indigenous territories in 2018 in Spanish and in English. We co-organized several seminars in the framework of this Rivers project, and we are currently co-writing a new piece as a continuation of the first piece that we co-wrote, from an autoethnographic and an interview point of view, to indeed unpack and entangle those different concepts of nature, environment, ecology, territory within the context of a post-conflict and transitional justice context. But we are very aware, and she even more, how difficult it is, how challenging it is to bring this kind of other conceptions that question what exists in the world into a legal framework and in a legal debate. And an invitation that we do is towards the legal world is questioning even the colonial and racial legacies of different key concepts within international law. This is a graphic that we put together to understand what is a territory living being as a victim of an armed conflict. And here I'm sharing several quotes of other indigenous scholars that indeed point to the fact that we have to start to recognize and to deal and to engage with their own questions about how knowledge has been produced, also legal knowledge within social science and in law, and why indigenous concepts and why indigenous visions and practices has been subordinated, excluded and marginalized, even up to date, also in the legal field. These are deep questions and difficult questions. It's not easy, and this short time is just scratching the surface, but it is an invitation to the legal world to start critically thinking at this point of the time of climate change about colonial and racial legacies, but also roots of many of the core concepts that we these days are questioning. And one of the many questions that rose, the fact that in Colombia, the territory or living being as recognized as a victim of the armed conflict, is to what extent the knowledge about the damage to the territory, the rivers, the mountains, the spirits. As I mentioned in the beginning, I learned that indeed the fact that the rivers has to swallow up all the dead bodies of the massacres, and that the river was suffering, was mourning because of all the violence that even a river and a sacred mountain that was destroyed, or in case of the Kichi in Guatemala, the sacred corn that was burned down, that it is a living issue and that has also what we would call violated its dignity and such. But to what extent the knowledge about the damage produced by indigenous ways of seeing the world, like dreams, fire, the ceremonies, etc., can indeed be heard in courts. Referring to the work of the Indian philosopher Spivak, can the subaltern speak? Yes, they do speak, but to what extent can judges and courts hear what they are talking? To wrapping up this brief intervention, what we are looking at within the Rivers Project, and also in collaboration with the Judge Belkis Izquierdo, is to what extent the colonial judicial model in the past and the present can deal and engage in a positive way with all this kind of historically excluded knowledge, and how can we transform.
Lieselot, please try to finish in 2, 3, 4 minutes, because no, in 2 minutes, please, or 3 minutes.
I'm already wrapping up, Carlos. Thank you. I think that's very. I can always share the slides, and I just want to share some of our publications that might support you, and also invite you to think about the colonial roots. For example, what we have been looking at when it comes to the concept of environment and nature, where does the concept of soil and subsoil and how it is legalized comes from, and to what extent these legal conceptions of soil and subsoil in the context of extractivism, like for example mining, has this impact until today on the legal framework of mining and the questions that indigenous communities are doing or questioning in their territories. And just as I'm very aware that this kind of questions might create quite a lot of doubts and might create a lot of difficult reflections about law and international law fields. One of the other work or lines of work that we are working on is the rights of nature, which is also one of those new emerging legal frameworks. And final publication that I wanted to share with you, if you're interested, is where we already look at these different concepts, and it is an invitation to the legal world to not to be afraid of these kind of what we call in anthropology ontological questions about the existence, about what is water, what is nature, what is environment, and what is ecology, but instead critically engage from the legal field with these deeper questions. And I will wrap up here with my very brief presentation. I want to thank everyone again. It's a pity that I can't see who is there in the room, but I hope that also with the special issue about transitional justice and nature, that we can continue this conversation, and hopefully next time in person. So thank you very much, and thank you, Carlos, and everyone there.
Thank you, Lieselot. Thank you very much for your presentation. And now we have 5 minutes for discussion, or not?
I wonder if there could be possible to merge the panels,
the final panel.
for debates, with the exception of Lieselot, because I'm afraid that she will leave afterwards. What do you think? Maybe possible questions for Karen and for Helen?
Now?
No, the opposite.
Okay.
And now just for...
Okay.
It is a suggestion. It's just a suggestion.
Sounds good. Okay. Sí, perfect for me. So we over the session, no? And we continue the question.
If there is any question for Lieselot?
Okay. Any question for Lieselot, please?
Questions for
sí.
Obregon could leave for the following panel after lunch.
Okay. Any question for reflection, observation, taking in relation to the Lieselot presentation? No? Then Isabel, no? Hernandez.
Thank you, Susan, and thank you, Monse, and thanks all the people here. Now we want to go quickly because I think we have no many time. And I am Isabel Hernandez. I am administrative law professor here at the University Carlos III de Madrid, and I'm going to introduce inside third panel. No, I think it's in the third panel of this morning. Musical pieces from el maestro Chilla Amos. And Chilla Amos is permanent conductor and advisor of the Irodai Symphony Orchestra, research fellow sustainability science at Hiroshima University in Japan. But first of all, this is two musical pieces from Maestro Amos Chilla. And they are going to at the final. No, first of all, Professor Ko Ken Lian, she's going to do opening remarks on the music and culture in promoting the implementation of environmental laws. Professor Ko Ken Lian, she is an emeritus professor, National University of Singapore, former director of APCEL, Asia Pacific Center of Environmental Law at this university and National University of Singapore, and member of its advisory committee. Also, she's ICEL governor, and she sent us a pre-recorded video. I'm going to put this one right now.
A very good day to all of you. Maestro Chilla speaks to the subject as a musician. Since his appointment as ICEL representative of music and culture for the environment, he has composed 3 music pieces, namely Voice of the Sea, Monochrome Burning, and Lost Migration. I speak as an environmental lawyer, using Chilla's 3 compositions as illustrations on how music can be a powerful tool to address environmental changes. In Voice of the Sea, Chilla's video on whales swimming in their underwater habitats speak to our peacefully, calling us to be stewards to keep their habitats pristine and their population sustainable. Are the international laws, such as the International Convention for the Regulation of Whaling and the ICJ case against Japan, effective? Not really, but it is heartening that more recently, the Intergovernmental Committee under UNCLOS drafted a legal framework on the conservation and sustainable use of marine biological diversity beyond areas of national jurisdiction. In Monochrome Burning, Chilla highlights the devastation of deforestation, which can decimate or degrade biological ecosystems. Deforestation also impacts on and exacerbates climate change. How do we deal with states and their investors in clearing land by deforestation to grow crops? Can they be responsible for crimes against humanity under the Rome Statute? There are various relevant UN conventions, such as the Bonn Convention on the Conservation of Migratory Species and Wild Animals, which inter alia protects these species throughout their range. How adequate and effective are these various laws? Chia's piece on lost migration demonstrates the plight of migratory birds, which, having flown thousands of miles to escape the bitter winter of the northern and southern hemisphere, only to land on desolate habitats. How heart-rending. This paper focuses only on one aspect of culture, i.e. music. A word on the role of culture in environmental law. In 2001, UNESCO, in contemplation of deepening culture, drafted the UNESCO Universal Declaration on Cultural Diversity. It defines culture as, to quote, the set of distinctive, spiritual, material, and intellectual emotional feature of society, and encompasses ways of living together, including value systems, unquote. Music and culture, like environment, is borderless and can have a universal appeal with their manifestations in dances, songs, poetry, art, and other inspirational delights. It can play a powerful complementary role of facilitating the implementation of environmental law and advance the aim of living in harmony with nature. The theme of the United Nations resolution and interactive dialogue on harmony with nature, adopted on 22nd April 2020, commemorating International Mother Earth Day. I will end with an invocation. Let 1,000 voices and sound of music for the environment bloom for the betterment of mankind. Excelsis. Thank you.
Thank you. Now we are going to listen to the two musical pieces. First, Lost Migration. And the last musical piece is Monochrome Burning. So that's all. Now, I don't know if we are relaxed or sad, but we are going to have a break for lunch, no? Yeah. Okay, thank you.